Hello friends, welcome to Pratibha Shorthand Academy. I am back with another video. Hope you like it. The dictation will start within 5 seconds. 5, 4, 3, 2, 1, start. At this juncture, it may be noted that the appellant in her application for stay of operation of the orders passed by the Sikkim High Court in the contempt proceedings has quite lucidly explained as to why the contempt notice could not be served on her, as a result whereof she could not present herself before the High Court. Stop. The appellant has explained that, having regard to the short time framed within which she had been directed to vacate the tenanted premises, she had to come to Delhi immediately in order to file the special writ petition giving rise to this appeal. Stop. She has categorically indicated that on 4/7/2006 she was in Delhi, and the question of avoidance of the contempt notice or any deliberate intention on her part to disobey the same did not arise. Stop. In her said application, the appellant has also mentioned the fact that her son had received the contempt notice and had thereafter telephoned her in Delhi, informing her of the same. Stop. Paragraph change. What is of grave concern is the fact that the learned judges completely disregarded the civil law relating to eviction and directed the writ petitioner on her writ petition for different reliefs to hand over the possession of the tenanted premises to the respondent number 2. Stop. The case in hand is an example of how the writ courts have in recent times either forgotten or ignored the line between the reliefs which could be given by the civil courts and the constitutional courts. Stop. The learned judges appear to have lost sight of the fact that they were deciding a writ petition for reliefs prayed for by the writ petitioner and not a civil suit for eviction against her, and in such a proceeding no mandatory order of eviction could be passed, and certainly not against the writ petitioner herself. Stop. In fact, after imposing the cost of rupees 1 lakh while dismissing the writ petition, the learned judges added insult to injury by directing the writ petitioner to also vacate the premises where she was running her business for about 30 years within a week from the date of the order. Stop. Paragraph change. While deciding the writ petition, the learned judges appear to have shifted their focus from the reliefs prayed for in the writ petition to what relief could be given to the respondents therein. Stop. This appears to be the reason for the learned judges to have passed a mandatory order of eviction on the appellant's writ petition, where she had inter alia prayed for a direction on the authorities to issue a fresh trade license to her on her husband's death. Stop.